you're watching BloombergQuint. The government and telecom operators today and other companies face the ire of the Supreme Court for failing to comply with its order on the recovery of AGR dues. Now, the Supreme Court went so far as to even threaten these companies with contempt of court for failing to comply with its order and pay up the money. The Department of Telecommunications has subsequently handed a deadline of 11:59 p.m. tonight to these companies, including telecom companies, to pay up. That's news coming in according to PTI. Now, to discuss the implications of the Supreme Court's order, I'm joined by senior lawyers on this show, HP Ranina and Sidharth Luthra. Thank you very much. And in a few moments, hopefully, we'll also be joined by Mukesh Bhutani. Before I get to my guests and seek any responses, I do want to point out how strongly worded the Supreme Court order today is. Three-judge bench led by Justice Arun Mishra said this about the fact that this order was passed several months ago and companies have not yet paid up these dues. They said this case projects a very disturbing scenario. The companies have violated the order passed by this court in pith and substance. They have not deposited any money so far. It appears the way in which things are happening that they have scant respect to the directions issued by this court. And then the bench has specifically mentioned a government official. They've said a desk officer of the Department of Telecommunications has the temerity to pass the order to the effect of issuing a direction to the Accountant General, another constitutional authority, saying do not insist for any payment pursuant to this order passed by this court and do not take any coercive steps till further orders. This is nothing but a device to scuttle the order of this court, the bench says. This kind of order should not have been passed by the desk officer at all. After which the bench says that in these circumstances, we draw contempt proceedings against the desk officer. And it also says that the managing directors and directors of the companies that have to pay up these AGR dues should show cause as to why the court should not initiate contempt proceedings against them for violating the court order. And in case the payment is not made by the 17th of March, then these managing directors of these companies will have to show up and be present in court. Mr. Ranina, having brought contempt now into this matter, does this leave the door open for anybody to seek any kind of relief or reprieve from the payment of these AGR dues, which run into several thousands of crores for individual companies and several lakhs of crores when put together?
None whatsoever. After all, the court has given the directive and the government has now, according to PTI report, asked them to deposit the money by midnight today. So it leaves nothing at all for the companies to do except to pay up. And if they don't pay up, then obviously they will have to face contempt proceedings on the 17th of March. When the court has fixed the case. Possibly they may pay up before that date, before 17th of March, and then seek some relief from the court on the ground that they had difficulties in paying. But that's a different matter. But as things stand today, they have no option but to pay up. There's nothing else that they can do, nothing whatsoever.
Mr. Ranina, what do you make of the very strong words that, Justice Mishra used both in open court today as well as articulated in the order? He's raised considerable objection with what the government officer, which is a desk officer in the Department of Telecommunications, also had to say when a notice was issued to the AG saying do not pass any coercive action against these companies if they do not pay up these AGR dues as ordered by the Supreme Court in its earlier judgment. What do you make of the way the judges have viewed this behavior?
They have taken a very serious view because it's nothing but open defiance of the order of the highest court. And if a desk officer has had the temerity to do so, I think it is outrageous because it completely undermines the rule of law. Now the desk officer has been told to give his reply, and possibly the desk officer may then point out that he was instructed by somebody higher up to make that order. Because can a desk officer pass such an order without getting any approval or any sanction from a higher authority? That's again another issue. So if the desk officer gives a statement that he had acted on the basis of an order from a superior authority, then that authority will also be in very serious trouble and will be subject to contempt of court proceedings.
Sidharth, Luthra, if I may bring you into this conversation with regards to what the outcome seems to be this evening, I want to take you back to the original AGR order in which the Supreme Court laid down a timeline for the payment of these AGR dues. And there has been some argument that maybe the court exceeded its brief in doing so, that it should have only ruled on the definition of AGR and whether certain revenue was to be included under it or not. And in actually putting out a timeline for the payment of these dues, it sort of made it very difficult for many of these companies for whom these amounts are very large.
Well, it is within the power of the court to stipulate the time within which there should be compliance of directions of the court. Having found that there is a liability for AGR, it is not that the court has acted has exceeded its powers in giving that timeline. But there is another issue which you need to consider. You know, a few years ago, we had a judge on this court, Justice Sikri, who talked about the economic impact of judicial decision making. And this is one of those classic cases where that element seems to have not been examined in its entirety. Of course, it's an order of the Supreme Court. The government is bound by it. Every citizen is to comply, whoever it's directed to is to comply with it. But there is the legal issue that arises that when courts pass certain decisions which have large-scale ramifications, financial ramifications, of course, making sure that the law must be complied with, but at the same time, the part directing period of payment ought to have been considered in terms of the economic impact, that if these companies can't pay as they've not been able to pay, what is the consequence that is going to befall not only the companies, but the citizen who is obtaining services from these companies. You as a, in the television industry, in the media industry, because of which I can communicate through your channel today because of what the services telecom service providers provide. So all of these issues need consideration, and in large scale matters of this nature, without being at all non-compliant with the law, these aspects of compliance in terms of period, in terms of time, need to be considered. There's another issue that I must raise is, and that's the other thing which seems to have attracted the ire of the court, that a desk officer is issued. Now, how it works in government, having spent a little time in government myself, the formal order may be passed by the Under-Secretary or the desk officer, but eventually the file is cleared till the Secretary or the Minister. The government had all of this time, perhaps to bring a legislation, perhaps to bring in a policy or rules or regulations, allowing them to sidestep the order of the Supreme Court in terms of a timeline, or by legislation or subordinate regulation, if permissible at all, to extend the period of time for payment of these dues, or provide another mechanism for payment or securing of these dues. That having been done, it could have been argued that it's not contempt, because a legislative action had overtaken the court, and that legislative action would then have to be considered whether it was, if ever, questioned by court. But that having not been done, a mere intimation by a desk officer, of course, it had to come down from the secretary level, because that's how government functions. And unfortunately, there is a problem that though secretary level officers and ministers take decisions, it is left for the desk officer to issue the formal letter, and that leads to a lot of stress that is often found in court proceedings, where courts react to these letters in anger or in despair, rather, as has been done. If you see the tenor of the order, the court has shown a certain level of despair that their orders have been overruled by a desk officer. It's not about hierarchy, but it's about people in the administration not taking responsibility for their actions, and that's what seems to be the underlying theme of the court's order. Now, the difficulty, as the speaker before me has said, is there's a timeline of today, and if that timeline is not adhered to, will these companies be able to effectively function at all or not? Are we seeing a change in the telecom industry which is going to be affected post-midnight today? These are serious concerns that need addressing. These are economic concerns. It is up to the administration, to the government, to consider how they're going to act. They can't be non-compliant with the court order, but at the same time, in relation to the period of payment, something which should have been done prior to the passing of today's order may have to be considered to come to the rescue of these companies, and eventually to come to the rescue of the consumer who avails service from these companies.
Yeah, Mr. Luthra, I'll get to what the role that the government has played in this, but I want to go back to what you said about the economic consequences of judicial pronouncements. And I think what was decided by the Supreme Court in the original AGR order has somewhat been compounded today. And I mean no disrespect to the court when I say this, but should not the court have considered, given that there has been enough reportage and debate around the economic consequences of this, not just on an entire industry, but on several public sector companies, which will have to cough up thousands of crores of rupees, should not the Supreme Court have considered that, yes, while they found the definition to include certain revenues, they should not press further on the payment of these within a limited timeline and allow for the government to determine how this should go down?
As I said, there is a legal aspect, which is the determination of whether AGR is payable or not. That's one part.
Right.
And one can really not question the court's decision on that. In fact, one
That's
can't
fine.
even
Not
question the
questioning
court on the
that. Not
timeline.
questioning. Yeah, not questioning
and there,
that.
the economic aspect was, and there, you're right, and we can't, because that's not an arena where the economic impact of the decision could be questioned. But on the period for compliance, on the manner of compliance, on what has been directed today, there the economic impact is a concept of jurisprudence which needs to develop in this country, which should have been considered, but as we see, the court has not done it, and now the consequences are to follow both for the government and for the service providers, which unfortunately may be very grave.
Okay, and I just want to come back to the point you made about the centre's role in all of this, right? The government is sort of well versed with the economic impact of this situation. It chose to kick the can down the road by allowing for a desk officer in the telecom department to say, hey, look, no coercive action will be taken against those who do not pay up according to the Supreme Court order. Should the government not have had a clear decision on how to deal with the outcome of the Supreme Court order? And if it had decided that we will not collect the money right now, it should have found the right vehicle in order to be able to implement that decision without offending the court. In this case, the government, in delaying the decision making in this process, has made a bad matter worse.
I would tend to agree with you in part, but we must understand the way the structures of all our ministries function. As I said, though a decision is taken at the level of the secretary or the minister, unless statutory required by law to be signed by the secretary or minister, it is invariably signed by the lowest functionary, that is the undersecretary or the desk officer. And I've seen this in government time and again, and that is because though decisions, the file moves from down to up, but then again it moves to the lowest level, because that is the person who issues the formal letter. And this is, for whatever reason, the way Government of India has worked for too long.
Mr. Luthra, forgive me for interrupting you. Forgive me for interrupting you. I don't have an objection to who issued the order. My point is, not taking coercive action is hardly a long-term remedy to this situation, where companies have to shell out thousands of crores of rupees in a limited time frame. In fact, a solution, if any, so as to not offend the Supreme Court and keep its honor, should have been a more comprehensive one, like you pointed out, a legislative one maybe.
Absolutely, absolutely. And as I said, I read what you said is what you said and what I had said earlier is that there needed to be a regulatory or legislative mechanism to ensure that either this payment was staggered or installments were fixed or the timeline extended, and that is a comprehensive solution to a problem. By just writing a letter to keep this, to not take coercive action, well, that's what's created the problem today, and we have a serious issue. And I think it is time that not just in this case, government needs to be more expeditious in its decision-making process, especially when large-scale economic implications, and considering that our economy is not as robust as we'd like it to be. These are important things, because the impact on these companies is not just an impact on these companies. It's on communication in India. It's on jobs. And let's look at it for another way. Let's look at the worst case scenario. If these companies decide to tomorrow say, listen, we can't pay, here, Government of India, take the keys to our company, we're moving out. The government will eventually have to put in all this money, or a lot of money, to ensure that these companies remain afloat, because eventually, today, communication through telecom service providers is one of the most fundamental services that you and I as citizens avail, you and I as Indians avail. and that will need to be protected. Citizens are going to be up in an uproar if tomorrow you or I find that we can't communicate on a mobile phone, isn't it?
Completely agree with you. I just also want to point out that it isn't just the telecom industry. GAIL owes 1.7 lakh crores. Power Grid owes 22,000 crores. Gujarat Narmada Valley owes 15,000 crores. Delhi Metro owes 5,000 crores. So there are several government entities here which will also have to pay up in accordance with the earlier Supreme Court order and, of course, today's very angry wording. I'm going to bring in, one more senior lawyer into this conversation, Mukesh Bhutani. Mr. Bhutani, thanks very much for joining us. So what are the options now except to pay up? And before you answer that, let me tell you we have some news coming in. Airtel has, in a letter to the Department of Telecommunications, said that it will deposit 10,000 crores by the 20th of February and the balance before the next date of hearing, that is the 17th of March 2020, as laid down by the Supreme Court today. Are all doors shut, Mr. Bhutani, for the centre to intervene in any fashion whatsoever now and try and give some relief to the telecom companies and the other companies that owe money under this AGR order?
Well, the Supreme Court is well within its right to consider the application for reconsidering not the judgment, but the plea of the telecom companies in terms of how they wish to satisfy the dues. But I think the ball, in my view, lies largely with the government, because if the government can come out with an ordinance or a statute which will work out a basis and help the telecom companies, that would be an ideal option. Because I think it's very clear that since the judgment of the Supreme Court in October 2019 and thereafter the rejection of the review petition, the ball was entirely in the court of the government and the telecom companies. It is also a known fact that the telecom companies have been in discussions with the government to work out a basis to satisfy the order of the Supreme Court, as well as simultaneously not subject themselves to financial difficulties. And to a larger extent, the government has been considerate, though it has not taken any definitive decision. And as a result of that, the telecom companies were not left with any option but to go back to the Supreme Court to, after the revision petition was rejected, to consider whether the payments can be made in installment.
But Mr. Bhutani, the Supreme Court is in no mood to relent, as we know very clearly today. So it now comes down to the government. You mentioned that it could move an ordinance or legislation. A legislation will take time. An ordinance at the point when Parliament is sitting might not be possible. So what is the immediate solution that the centre may provide, if any at all? Or is it now very clear that all these companies will just have to pay up by the 17th of March?
Well, if there is no possibility of the Supreme Court reconsidering the plea, which is very evident from the verbal arguments that happened in the court today, then I think the ball is in government's court for them to pass an ordinance. I don't see the difficulty, why they can't do so, particularly given the fact that an ordinance is more an executive decision rather than having a full session in the Parliament to be able to pass a statute to give effect.
Let me ask my other guests for an answer to that question as well. Mr. Ranina, do you see any solution or way out at this point in time if the government chose to intervene? I'm assuming an intent on the behalf of the government, but if it chose to intervene, does it have any room to intervene?
Well, it can't introduce legislation in Parliament because Parliament is in session right now. And they can certainly bring in legislation immediately, because ordinance can generally be issued only when Parliament is not in session.
Yeah.
But when the Parliament is in session, the legislation can immediately be brought in. So certainly they should bring it in. But what surprises me is this news report which says that they have to pay up by midnight tonight. Now that is something, I don't know why the government has acted so hastily. They should have considered this matter and maybe considered the option of introducing legislation in Parliament next week instead of passing this order, which again ties their own hands by saying that you better pay up by midnight.
What would the nature,
Mr.
Ranina, what would the nature of that?
I don't know how the government functions.
No, what would the nature of that legislation have to be so as to maybe in some ways honor the intent of what the Supreme Court decided, or can it fully overturn and go back to the root of the AGR definition altogether?
No, I don't think it can overturn the AGR definition altogether at this point of time. But the only legislation will be more of procedural and giving them the timeline, the time frame, fixing the time frame for paying the amount. And then on the 17th of March, they will inform the Supreme Court that this legislation has been passed. And if the Parliament has passed a certain legislation, this is something which the court will generally accept because it's more of an executive action. And normally courts don't interfere in executive matters.
Sidharth, Luthra, would you agree with that, that there is still maybe a sliver of hope or a slight room or window of opportunity for the government to still intervene and spare both telecom companies and other companies the full brute version of this order of having to pay in such a short period of time?
I think the government's reaction in asking the companies to pay by midnight today was a knee-jerk reaction. It was a very hasty decision which should have been perhaps a little more reasoned. There was and is scope for legislation or legislative amendment to be brought to either extend the period or perhaps even relook at the basis of liability, because the law in this is that if a court gives a certain verdict and Parliament wishes to consider that issue again and take a different view, it can only do so if it changes the very basis of the court's verdict. It cannot just pass a decision to block or negate a court's verdict. That's not permissible. Any legislation which does the latter will be quashed by the court. So that's the principle of law. If you take away the basis of the court's verdict and bring out a legislation and change the parameters on which the decision making should have been done, then that legislation will stand, otherwise not. Secondly, as the speakers before me have said, the manner of collection of dues, the payment to be made, the stipulation of time, that's something which I believe the court could have, the Parliament or government can definitely would have dealt with or tinkered with, and they still have a chance to do it. But the fact that they have asked for a payment today will create a doubt and will make it rather difficult for them to get any legislation through, because you can't have conflicting decisions taken contemporaneously, and that will show things in a very poor light when it comes up in court.
Mr. Luthra, can I follow that up with a question on whether the government can treat different companies differently? And by that I mean that if this PTI report is correct and the government has asked for telecom companies to pay up before midnight today because they've been scolded by the Supreme Court, the government should also be insisting that the other companies, which are non-telecom companies that also fall under the purview of the Supreme Court decision, should also pay up, right? And that includes the Gas Authority of India, or it includes Oil India, or it includes Power Grid. Should it not insist that those companies also pay up today itself?
Now, the point really is, if a distinction has been made by court, the government can follow that distinction. Secondly, what is more important is...
But Mr. Luthra, there is no distinction made by court.
You know, under the Constitution, just just allow me a moment.
Sure.
If a distinction had been made by court, the government could have done it. Otherwise, under Article 14, the government can deal with provide reasonable classifications, and different classes of entities can be treated differently. Perhaps that is the justification the government has done as government corporations versus non-government corporations, because if they are government corporations, it's really taking from one pocket to the other, whereas from private corporations, the government may have a belief, rightly or wrongly, that there may be a different of collection. That there may be an issue regarding how to collect from private entities or private operators, and that classification is possible. Having said that, today, all the government has tried to implement what the Supreme Court ordered to avoid further issues on contempt, and while they've done it partially, they've tried to mitigate the rigors of contempt that may follow in March of 2020. So that's hasty, but not legally questionable. At the same time, I agree with you entirely that if that was the case, then governments treating different sets of companies differently is also a matter which is very onerous. Although the justification would be public interest, as in public sector versus private sector, and that's a plausible explanation which they may give when they come to the Supreme Court. All this is something to be seen in the future. Right now, as I said, what is more concerning is that the failure to act in the past, the hasty action to this evening to pay up by the midnight, and my apprehension is because of this hasty action, there is going to be no follow-up reprieve for the telecom companies, and that's a serious concern for all citizens and all of us.
Okay, fair enough. Mr. Bhutani, I'm reading the order. I can't, on the face of the order at least, I can't make out, and I apologize in advance if I'm proven to be incorrect, but I can't make out any distinction that the court has made between telecom companies and otherwise. And while I take Mr. Luthra's point that, you know, the other companies, several of which are public sector companies or central public sector companies, it's somewhat money going from one pocket to the other. I should also point out that many of these are public listed companies, and therefore any money that is going out of these companies into the pocket of the government also belongs to public shareholders. So I come back to my point that I put to Mr. Luthra, that should the government not have a uniform treatment of the dues payment across all companies, telecom and otherwise, which so far doesn't seem to be the case if the PTI report is to be believed. And I think, you know, sort of a corollary to that is whether they can treat any of these groups of companies differently, or whether any of these companies can seek relief differently any further.
Well, as Sidharth rightly pointed out, that if the government discriminates the telecom companies from the non-telecom companies insofar as dues are concerned, then subject to Article 14, it has to be done keeping in mind the constitutional provisions. But before I comment on your question, I'm not even sure whether the reworking of the dues payable was a petition that was filed only by the telecom companies, or the other public sector companies were also a party to it.
Well, right now it's only the telecom companies that filed the reworking, but the original operating order, which is the original AGR order, is incumbent on all of the companies, isn't it?
Correct. In that case, the government order for the telecom companies to pay up makes sense. I would presume that there is an inbuilt presumption that the non-telecom companies would be compliant with the Supreme Court decision and would pay up. Perhaps the non-telecom companies were following a wait-and-watch policy because the larger dues were due from the telecom companies. But that's a call that the non-telecom companies have to take. I think what is the other important aspect which needs to be borne in mind, and this is, Menaka, your research colleagues had put out the impact that the shares of large banks who are, bankers to the telecom companies who are under debt, and how they got impacted. So I think, we covered the implications, if any, on the larger economy. We covered the implications on availability of services. But I think what is equally important is that in today's environment, what implication does it have on banks and institutions who are the biggest lenders to the telecom company? So a more holistic view has to be taken by the government. And that's the reason I mentioned earlier that the ball lies squarely in the hands of the government, and it's taken me a bit by surprise if the government has given just a day now to fork out the dues that are due to DOT.
I should point out that while we are relying on that piece of news, it is a PTI report. I've yet to see the final notification of it. So maybe, it's not fully accurate, and maybe the government will consider more time period, at least till March 17, because that's the time period that the Supreme Court has given. One final question to all three of you for quick answers then. All of you seem to agree that the ball is squarely in the court of the government, as Mr. Bhutani put it, and all of you have articulated, and that the next step or next course of action should come from the government, and that it should be an effort to try and legislate at least a longer payment time period for the companies, both telecom and otherwise. Would you agree with that, Mr. Ranina, that that is something that needs immediate attention, and that's what the government should be doing?
Yes, I entirely agree with you. That needs to be done and done immediately. Fortunately, Parliament is in session and they can certainly act next week itself and come up with some clarification on this issue.
Mr. Luthra, is there any way to sneak this into the finance bill?
I think it's possible to do so, and I think the government should also have a relook whether they can work a way around, bring in legislation to see if they can come out of the rigors of the Supreme Court judgment. Difficult, but legally possible.
Let me also ask you a question to the mind of the government, as you lawyers put it. Given that it hasn't done anything much so far, except to say no coercive action will be taken, it's lovely that we're discussing the fact that the government should do this. But do you think it's likely to do this at all, Mr. Luthra?
I think there have been a lot of other things on this government's plate with the Delhi elections. Perhaps the Supreme Court order today is a bit of a wake-up call. And as citizens, as Indians, as lawyers, I think we can only hope that there will be a positive action on the part of the government, keeping in view the dignity of the court and its orders, and at the same time realizing in taking into consideration the economic impact. As Mukesh rightly said, it's not just the companies concerned. Look at the financial institutions which are funding those companies. Their bottom line is going to be gravely hit. There are the large-scale ripple. There are going to be scores of service providers who are going to be damaged, possibly, and perhaps even irretrievably. So all of this needs quick, effective, and conscious decision-making. And, well, as a citizen, I expect my government to act fast and effectively.
You put it politically correctly. Let's ask Mr. Bhutani for the last word on this. Mr. Bhutani, you've got your ear to the ground when it comes to government action. Do you hear of any rethinking of this situation whatsoever in order to be able to offer some relief to companies?
Menaka, I wish I had an answer to your question. Suffice for me to say that it largely depends on the political will. If the political will is there, this issue can be sorted out in an amicable fashion. If you saw the decision taken by the cabinet day before yesterday, they fine-tuned the Vivad scheme, which was largely an income tax settlement scheme. It came as a surprise, though a pleasant surprise to me, that they equated income tax dues to dues recoverable by the Debt Recovery Tribunal. So if the cabinet can meet and carry out an amendment to a bill which was introduced in the budget, I'm sure nothing stops the government from including telecom dues as well. By doing that, the government will not just be able to, resolve the current crisis that the telecom company, as well as other stakeholders, find themselves in, but it would also be able to, give dispensation insofar as interest and penalties are concerned. What we see today as a total dues from the telecom companies on the issue of adjusted gross revenues includes the penalties that have been levied by the DOT for all these years. So I don't have the breakup, but I'm sure that the dues would be substantially less. So if you include these dues together with the bill which is already in the parliament, I think this issue can be amicably resolved. Besides embarrassment, if any, that could be caused to the board members if they have to go and present in the court, which is what the Supreme Court directed today.
Hey, just a follow-up procedural question, Mr. Bhutani, and that is that if the government were to take some legislative action, as all three of you have recommended, how does it sit in terms of whether companies will still have to find a way to pay up between now and March 17th, or is it just that government legislative action will put a halt or a stop to the payment requirements under this Supreme Court order, or will the companies have to go back to the Supreme Court and say, look, this is the legislative action that's been taken, so now can we, be free of any contempt charge and yet not pay up?
I think it's entirely up to the government if the income tax and the DRT scheme is kept open and there is complete dispensation from all penal consequences if payment is made until March 31, and if the payment is made before June 30th, it's entirely up to the government as to how they, word the bill.
I think my question was a little bit more specific, saying if they were to pass a legislation that said, look, you have 3 years to pay these dues, we forgive penalties, whatever, hypothetically, what happens next? Because the Supreme Court has laid down March 17th and asked for the officers of these companies to be present in court if they don't make the payment. So do these companies have to then go back to court and say, look, here's the legislation that relieves us from having to do this, please take cognizance of this and also relieve us from any threat of contempt charge?
Sidharth, to answer this question, whether if the government comes out with a bill of this nature, whether the Supreme Court can come back and initiate the contempt in that situation, but I would just follow the first principle of law, that the Parliament is supreme, and if the Parliament brings out a law which is along with a validation act, which clearly specifies that this is the intent of the amended law and the economic rationale for that, I don't think that there should be any risk of contempt. But I would defer the answer to that to Sidharth, because that's his area of practice.
Mr. Luthra, you want to quickly field that for me before we just close?
Yes, of course. Yes, of course. I would like to say that if the government was to bring out a legislative mechanism or law to defer the payment and reduce the penalties, it would be for the government to place that before the court and to point out that the basis of the decision in terms of recovery of money has been taken away. Therefore, there should be no action for contempt. But as I said, it will be for the government to front-end it, because the beneficiaries are the companies. They would possibly not be listened to as effectively as the government. And as Mukesh rightly pointed out, the government will have to justify the economic rationale, the social impact of its policy that is brought out and the legislation that it brings out.
All right, fair enough. Gentlemen, thank you so much.
And the adverse consequences that we wanted to avoid.
Thank you very much, Mr. Luthra, Mr. Ranina and Mr. Bhutani, for joining us today and sharing your legal interpretation of where this battle heads next. As all three of them have articulated, this ball is now squarely in the court of the government to see if the government were to take any legislative action that could offer relief to telecom companies and the other companies that fall under the purview of the AGR order, given the larger economic consequences on the telecom sector and on lenders to the telecom sector and to several of the other stakeholders in the other companies. So let's see what happens. This is a developing story for now. We'll keep you updated on BloombergQuint.com. Thanks very much for tuning in.